And so really the main goal for this discussion was to really celebrate the students. This is not really about me, though it has happened where they've been doing a lot of work in relationship or connection to me, and in particular as it relates to combating race-based natural hair discrimination and really advancing what I have described as the Free the Hair movement. But really this is about the students and to really showcase the positive outcomes of student investment in their learning, as well as the application of knowledge and skills acquired through the Drexel Klein School of Law curriculum, externship programs, and the newly established Faculty Fellows program that came about in the wake of the eruption of COVID-19. So in turn, this program also seeks to highlight the myriad ways each member of the Drexel Klein law school community helps to create not only impactful student experiences, but also really aids in cultivating critical professional competencies, including cultural competency. Because of the positive collaboration and extensive conversations with my research assistants, Tamara Denal and Kayla Panic, as well as an email that came about by third year Richard Crane, who unfortunately is unable to be with us today, but he informed me that he was serving as an intern for the Wisconsin State Representative, Sheila Stubbs. And she actually is a sponsor of the Wisconsin Crown Act. And he was assigned to support this particular bill that is very near and dear to my professional life's work. And so in I guess the convergence of working with these incredible students, having Richard Crane in my employment law class and actually engaging in this work that I've been working on, or collectively we've been working on, it really inspired me to develop a new class by converting my seminar on appearance and grooming codes discrimination into a legislative practicum this semester, which this is where Sarah Lee enters. She is one of my students in the legislative practicum. And the real goal of that is to try to help students have some real-time exposure to underexplored aspects of lawyering, like lawmaking through legislation, international legal research, as well as state and municipal legal research. And something that we probably don't think very much about is collaboration, collaborative teamwork, as opposed to competitive isolationism in the work that we're doing. So again, many of you all in the community may have already heard about my engagement, the Free the Hair movement, and engagement in combating race-based natural hair discrimination. But I really wanted to highlight that behind the scenes, there are these Drexel Law students that have played important roles in the advancement of these recent legal reforms to redress this systemic form of racial discrimination that African descendants experience in various spheres and across the globe. And so to frame our conversation about race-based natural hair discrimination, just in case you might be saying, what is that? I thought it might be helpful to introduce the topic with a recent PBS NewsHour segment, which explores how hair discrimination impacts Black people in their professional and personal lives.
Last month, Connecticut became one of a growing number of states to make race-based hair discrimination illegal.
We do see, this elevation, this privileging of straightened hairstyles as good hair.
To protect Americans against this form of discrimination, Drexel University law professor Wendy Green has worked with legislators around the country to create the Crown Act. It's a law that bans discrimination in workplaces and in schools against hair textures or styles linked to racial identity.
It really clarifies that natural hair discrimination in all forms constitutes race discrimination. Our hair has nothing to do with our competencies and our qualifications and our abilities, and therefore shouldn't have anything to do with whether or not we're afforded employment opportunities or we should be included in certain spaces.
In 2019, California became the first state to pass the Crown Act. Since then, 7 states have followed California's lead, in addition to a handful of cities and counties.
I rise in strong support of H.R. 5309.
A federal version of the Crown Act passed the House of Representatives last fall, but stalled in the Senate. Green says part of the challenge is getting others to see the realities of hair discrimination.
What do you say to people who say this is just hair, just like grooming and dress codes?
hair discrimination doesn't really exist because you have to have different standards for different parts of our society?
Well, I think individuals who say those types of things really are uneducated or undereducated as it relates to the long-standing form of racial discrimination flowing from our hair texture, similar to our skin color. It harkens back to eras of racial slavery and apartheid in this country, as well as around the world. Just because that may not be your experience, doesn't mean that this experience of discrimination is not real. Okay. So again, just wanted to frame the conversation so people could have an understanding of what we were talking about in terms of race-based natural hair discrimination. And so in terms of this, I'll just kind of give a brief overview of what the students have been doing. They've been busy. They've been busy freeing the hair this past year. And so in terms of my research assistants, they've been involved in, supporting different forms of legal advocacy and public engagement, from doing research for non-traditional scholarship that I've written, like rewritten judicial opinions and conventional legal publications like book chapters and law review articles. They've also been involved in assisting me as I've been crafting and advising on civil rights legislation, clarifying that natural hair discrimination is race discrimination. They've assisted with written testimony on behalf of over 250 legal academics in the United States, that this testimony was entered into the legislative record, into the public record, in support of the Federal Crown Act, which was passed by the United States House of Representatives in the fall of 2020. And I had the pleasure of privilege, really, of co-drafting. They've also assisted with media requests, whether it be something like PBS NewsHour or the Washington Post, related to grooming codes discrimination and public accommodations in workplaces. And they've also conducted research in support of not only professional presentations that would be to a variety of audiences, but also expert witness testimony in the high-profile civil rights case, which was discussed in the PBS News story involving DeAndre Arnold and his cousin Caden Bradford. That discrimination lawsuit was filed on behalf of the NAACP Legal Defense Fund, and that type of expert witness testimony, both written and oral, included both state, well, not both, but included state, federal, international, as well as interdisciplinary research in order for that to come about. And then on a separate category, they've also helped with, it is a special category in and of itself, was international for preparation for this globally viewed, what I then learned later, interview with civil rights icon, Dr. Angela Davis, for the Birmingham Civil Rights Institute, in awarding her the Fred Shuttlesworth Human Rights Award. So been very, very busy this year. And then in the legislative practicum, the students have been able to really experience in real time what it is to advise legislators, namely on the state level, as it relates to creating civil rights protections, not only as it deals with race-based natural hair discrimination, but other forms of discrimination on the basis of changeable or mutable characteristics. And they have been involved in assisting with legislation in 3 states, Nevada, Louisiana, Nebraska, and unbeknownst to them, also Michigan. And they're also helping to, and all of the students combined are helping to possibly push forward some advancements in the UK. So there is a project that they're working on for a presentation that I'll be doing next month for the House of Commons there. So I just wanted to give you an overview of all the things that the students have been doing to combat not only this form of racial discrimination, but also other forms. So here we go. Students, if you're ready to get involved in this conversation, before starting, and I'll direct this to Kayla and to Tamara, before you began working as a research assistant, what did you envision being a research assistant would really be like? A research assistant for a law professor. What did you have in mind, if you had anything in mind?
So I'll just say very briefly that I don't remember what I thought this was going to be like, but I don't think I understood the breadth of what you do, Professor Green. So as you just described, you do such a wide variety of things. And I don't think coming into this, I guessed that I would be helping out, not just administratively, but also substantively with a lot of your projects. A lot more than I thought I was going to be able to do.
So when I started, I had just finished my first year of law school, and the pandemic had just hit. So I really thought it was going to be like more mundane, like maybe looking up cases, doing case briefs, and it ended up being nothing like that. It was super practical and actually very interesting. So that was exciting.
Okay, so back on you. What was your favorite, well, you can say your most favorite part and the part that you didn't like the most. I'll give you that too. If you want to talk about it, but you don't have to. What was your favorite part or favorite aspect of serving as a research assistant? And then for Sarah too, in terms of now being in the legislative practicum thus far, what do you think has been your favorite part of serving in that capacity?
I will start off by saying that just before everybody got on the call, we were talking about how I don't think there was a part that we didn't like, because even the kind of mundane tasks like citations always turned into something bigger, like for one of your presentations for legislatures. So we got to see all of the work that we did really turn into a much bigger project. And I think one thing that I'd love to discuss with everybody is the research that we did for your expert testimony on the DeAndre Arnold and Caden Bradford case. And I'm not sure if you wanted to give a little bit of background on that before I jump into what we got to do.
Oh, sure. So that case, many of you probably already familiar with it in light of the video, but if not, essentially the two students were told that they had to cut off their locks in order to continue matriculating in their high school in Texas. And this was in accordance with a grooming policy that barred male students from wearing shoulder length hair or hair that appeared to be shoulder length if it were let down. So even though they were wearing their hair pinned up, the idea was that if it were to be let down and had the propensity of touching their shoulders, and therefore it violated the grooming policy. So the LDF brought this lawsuit against a civil rights lawsuit against the school district. And in particular, they claimed that it was a form of racial discrimination in violation of the 14th Amendment, also sex discrimination in violation of the 14th Amendment, and an infringement upon their First Amendment rights to cultural expression. And so one of the major points that I had to testify about and give some information on was about that first, well, both race discrimination as well as cultural expression, and the fact that wearing locks for many African descendants, especially of West Indian ancestry or descent, is a function of their cultural traditions and expression of their cultural heritage. And so the students had to look into this. And Kayla, if you want to talk about what you uncovered or did not uncover, what you thought you might uncover as it relates to that particular legal point.
Sure. So I will preface this by saying that all of Professor Green's research is grounded in a lot of historical context that we did a lot of digging on. So specifically, I think the only assignment was to see if I could find any research on or even just writings or discussions that people have had on the historical and cultural significance of locks. And so I was able to pull from lots of, online libraries I've found really useful, especially during the pandemic when we don't have access to the in-person Drexel library. And from articles that maybe we wouldn't have looked at because they're not legally related. So I think one huge thing that was important to Tamara and I in our research was like sociological and psychological articles, or even articles that maybe were written 50 years ago that nobody was looking at it at this time. I think that during researching for these different projects, we were able to be creative in ways that I had not anticipated when I started working for Professor Green.
And similarly to Kayla, that was also one of my favorite projects. I also sat in on the preparation for Professor Green to be the expert witness, which was also very exciting because, again, I had just finished my first year of law school and I had never like stepped into a courtroom, never seen actual lawyers prepare for a case. And it was interesting to see like how many times they like ran through the same question like over and over again, making sure she was able to hit the point that she wanted to hit, while also doing the research with Kayla, finding articles and outside research to help prepare for what I thought before this was a small part in the case, which actually is a huge part. So that was also very exciting. And secondly, was definitely also helping prepare for the Angela Davis interview. She's also one of my icons, so that was like super exciting as well. So we had a lot of great opportunities over this past year working with Professor Green.
Yeah, and also I will just mention in terms of the expert witness testimony, my testimony was being opposed too. So there was that. So we really had to drill down and ensure that the judge would actually admit me as an expert witness. So that was quite interesting to find out that a motion had been filed pretty late in the game, but that's what lawyers do, right? To try to get evidence out, but we were able to get it in. Also related to that, one last thing, do you guys want to talk about the international research, the UK case that you found in Jamaica cases really quickly that helped to support this point about locks being a function of cultural expression? And that was actually pretty instrumental too in the case. Either one of you want to talk about that one?
So I will say it's been a while since I visited the Jamaica case, but just to touch on that, in doing our research, I found that a lot of it overlapped in terms of Professor Green would ask us to keep an eye out for international cases, keep an eye out for things in different states. So even when we were researching, for example, for the expert testimony, we were keeping an eye out for cases that were happening internationally and are still, popping up here and there. But
the Jamaica case, I can say, was actually interesting to me because my father's side of the family is actually from Jamaica. So I actually like spoke to them about what was going on because it actually surprised me actually because like I would think that a country that's a majority African American, like this wouldn't be an issue. So again, like this research again opened up our lens to like this is not just like an American problem, but like even in countries that are predominantly Black descendants can still have this type of like stereotype against natural hair, which was also interesting. Also, when we like look at history and like why that is even a problem within our own community. So that was interesting to me.
Okay. Sarah, would you like to chime in and tell us what you've been doing over in the legislative practicum?
I can definitely say that all of it is my favorite, but if I had to pick, the most exciting part of the practicum is that Professor Green is constantly being, well, first of all, monitoring the legislation as it's being proposed in states and the federal government, and obviously overseas. But that she's often called in to consult and review legislation. So we had a lot of surprise, like, surprise, here is a draft of a bill from Nebraska. And she would let us have at it in class and outside of class. What do you think of the language? And teamwork makes the dream work. So it's really fun to have these conversations with our small group as a class. And also to really dive deep on the unintended consequences of word choice and legislation. Like they say, the road to hell is paved with good intentions. And I think we saw that a little bit in the legislative process, that well-meaning legislatures would put forth like some kind of bill that would just be completely impotent if it passed the way it was written. But it was amazing to have access to Professor Green's brain while we were thinking through, what we would do in our, in our novice law school state. Like, what would we do if we were drafting this bill? And to dig into the state law to see whether the protections were adequate given what was already the protections afforded by Title VII obviously aren't enough. What did the state constitution or the state law offer for, civil rights protection and what kind of case law existed. Was the state like very hostile towards natural hair in case law in the past, or silent, or it was just very, very fun and interesting, and more than all of that, like very meaningful to get to participate in that process from, I don't know if there's a backseat driver or like a third row driver, but very fun to engage in the legislative process that way.
Wonderful. Thank you, guys. And you probably uncovered how critical one little legal principle can be. We've been basically, the whole thing that we've been doing is trying to combat what we know as the immutability doctrine. And you probably are going to be so over hearing about immutability. But that's basically what we've been doing, is try to deconstruct and dismantle this legal fiction in our civil rights jurisprudence that has served as a barrier, frankly, to civil rights protections, not only against race discrimination, but also sex discrimination and even national origin discrimination in workplaces and beyond. So really what this legislation is doing is trying to overturn, 40 years of that precedent of reinforcing immutability as the basis for civil rights protections. And so that's one other thing I will say, that you might not have really thought that you could spend an entire semester or an entire year just operating around this one or addressing this one legal doctrine, right? So really quickly, to this point, what experiences as a research assistant or as a student in the legislative practicum really have reinforced, what you have learned in either the core curriculum courses like legislation or constitutional law, or possibly elective courses that you've taken like employment law and employment discrimination?
Just to go back to what Sarah said, we have kind of the same discussions every time we meet as a research group that you are having in class. So for me, I got to look back on my experience in employment discrimination after having worked closely with this legislation as it's being developed, and then reading the existing anti-discrimination legislation that different states have in their different areas, such as public accommodation and education. And then understanding what impact the choices and concessions that legislatures are making when they're developing the legislation. So for example, you mentioned that certain word choices can make the legislation impotent, and we've had lots of discussions about the significance of the phrase historically associated in the context of the Crown Act, because it would limit the reach of the definitions in the Crown Act in a way that Professor Green had never anticipated. And before working with Professor Green, I didn't understand. I thought that legislation, especially anti-discrimination legislation, was kind of a monolith. Like once you had a template, it pretty much followed the same format everywhere. But there is a lot of nuance when legislation is being crafted that I did not see before.
Probably the leg reg class, because when I took leg reg, I actually hated it. And since working with Professor Green, I would say that a lot of like the tools that we learned while taking that course was implemented in a lot of the research we were doing, and deconstructing a statute and looking at legislative history, like actually having that practical application of the skills that were learned within the class was super helpful.
Leg reg was what I had a little bit more fun in leg reg, only because I was also doing pro bono work with a child advocacy organization, and the director I was working for was actually doing very similar work in child advocacy as to what Professor Green is doing. She's constantly giving legislative testimony and proposing stronger laws to protect kids. And so I enjoyed that class a little bit more, just because, I mean, I think it's a pretty important tool, but it's not that interesting unless I think you're using it in some way. But it's amazing how like practical, and actually even, I don't know, I feel very passionate about the use of these like silly doctrines and like expressio unis, or like how should you order your list, or how have things been interpreted, or how will they be interpreted? When will somebody consult the legislative history, or when will they not? You know, in trying to like construct these watertight pieces of legislation. So that's really neat. And I'm also in admin law, so I'm seeing how that like plays out in the context of like administrative rules and procedures right now, and it all matters. It's way more interesting than I gave it credit for, you know, before I entered the practicum.
Well, I'll have to say, I appreciate the fact that you all actually take legislation and regulation as a required course in the first year. I think it's a critically important class and should be required of all law students. But also, I know it has helped me when we have been going through you know, I may be thinking that, you know, including certain words in a particular piece of legislation will be effective. But then you guys have confronted me and said, no, that probably is not going to be the best way. And it's changed my mind too about, you know, as you're talking about including certain words, even in terms of sequencing, taking out certain words to ensure that the legislation is actually effectuating the goals, right? Especially when it's on the ground and it's being litigated, it's being enforced, it's being used by those who are suffering discrimination, right? We want to ensure that it's actually going to give the most robust protection possible. And one little word matters, right? One little word can actually destroy that possibility. And so I appreciate the fact that that is a part of the core curriculum at Drexel, and that you all were utilizing those principles and those concepts as we were advising and reconstructing legislation. So I really appreciated that. And also your willingness to share it too. So that's really important. To that point, you know, oftentimes we hear that the primary goal of legal education is to ensure students think like a lawyer. And we may not always really fully explain what that means, but just wondering in your experiences, you know, whether as a student or as a research assistant, you know, what does that really come to mean for you? What are some of the ways in which, you know, you are thinking, acting, possibly writing, possibly pursuing solutions to legal issues that would be incumbent upon you as a lawyer?
I would say that for me now, like thinking like a lawyer would mean we get like one topic. So say we're talking about natural hair discrimination, but now we figure out that it also applies in employment law and grooming codes and like education and housing. So when you have like one issue, there's like a domino effect. There's so much more that you can go. Like sometimes that means limiting yourself, but also expanding yourself. And also when you're stumped, again, this is why it was great having Kayla as another research assistant, like being able to bounce ideas off of each other also helped us widen our lens. So I think that this experience has helped stretch our brains a lot in a good way.
I'll jump in. I second all of what Tamara said, and for me, I think of like thinking like a lawyer as kind of like, I don't know if anybody plays chess or whatever your strategic game of choice is, but anticipating the move that's coming next. So especially in the legislative practicum, reading cases and anticipating the argument of opposing counsel or whoever might be trying to like decrease the civil rights protection of you know, a potential client in the future when a piece of legislation is in place. You know, what arguments might they make using this language that could actually harm the clients we're trying to protect, harm a person that's been discriminated against in the workplace or at school, or and that has helped me a lot of ways as I piece that together with the anecdotes of what actually happens to people. We my classmates and I looked up a lot of just like news stories. Not everything makes it into a courtroom, but how are people actually being treated and why? And the hope is that if this becomes, which I hope it does, federal law soon, and takes effect in every state, that that the culture will change, and the protection will spread, not just like from a legal protection, but also from like this kind of cultural standpoint. But the opposite, thinking like a lawyer, is like anticipating the opposite of that as well, and just seeing how this has gone. And it's really quite upsetting to read these cases and think that actually like judges and lawyers have made and accepted these arguments that are just very anti-civil rights, in my opinion. So it's very, very useful lawyering skills, I think.
And then for me, something that we've been hinting at throughout this discussion is I did not realize that lawyering presented so many opportunities for creativity. So I've been able to be creative this year and try to have a more open mind about possible solutions and trying to stretch my own understanding. So Tamara and I would have an assignment. We'd think we understood what the product was supposed to look like and what information Professor Green was looking for. And then over the course of the assignment, what we started with was not what we ended with. The breadth of what we were looking at was so much larger, and things that we never thought would be helpful in the legal context became helpful, like I mentioned before, really old articles, or even for one, the revised opinion that Professor Green did, I was looking at articles from popular magazines from the 1940s, or I researched bell hooks for one of her articles. So just being able to have creative solutions, or even solutions that you haven't even come up with yet, just being open to what might come down the line as you're doing your research is something I'll be taking with me as I graduate.
Wonderful. Well, just really quickly, did you all already think that natural hair discrimination, I know, Kayla, you already know the answer to this question, but for Sarah and Tamara, because you were in the seminar on appearance and grooming codes discrimination, so that's why I say that. But last year, but did you already think that natural hair discrimination was already being treated as race discrimination before you started either in the class or as a research assistant? Just kind of curious. And then therefore you might have even thought that, why do we need legal reforms to address this issue? What did you think, Sarah?
Well, I would say that I would have thought that. I think I did think that, but prior to the class, I heard you speaking on like WHYOI NPR. So, that put me in my place and helped me to understand. But my dad's a retired lawyer, and, I just like put it by him as a hypothetical, like, in this case, like, is this protected? Is this race discrimination? And he was like, absolutely, if you discriminate based on the hair. And I was like, no, like, that's, you know what I mean? Like, depends on what state you live in and what's on the books right now. So I think like even people practicing law who maybe aren't practicing in the civil rights field or specifically with like race discrimination have no idea.
Sorry, I actually did not think it counted as race-based discrimination prior to this work. I actually didn't even really know there was like a whole like natural hair discrimination like movement happening. Like I thought about it more of like just a interpersonal thing. Like I didn't think that there was this whole like movement around it and legislation happening. So it was like actually like really exciting to find out that there is this movement happening.
Thank you. So one last question before we open it up to our attendees is, what could you name, if you have one or two or three, whichever you want to go with, in light of everything. And before I go there, I think one of the things that Sarah pointed out is, you're surprised at how, members of the profession are actually perpetuating this kind of discrimination and really kind of calcifying it as, a norm, a cultural norm, and something that, cannot be sort of combated through our legal regimes. And I think that's really something that we often don't think about, is that the role of the law. Sometimes I think for me, especially, when I was younger and thought about being a lawyer, I always thought of it that we were trying to eliminate discrimination through the law, as opposed to possibly calcifying and perpetuating it. So it's this tension oftentimes that we are having to deal with. And I think this particular issue really does help to illuminate that tension, that the law can be used as a tool to liberate, but it also can be used as a tool to oppress, right? And what is our role in trying to ensure that when we are offering legal arguments and legal perspectives and legal decisions, that we are in the business of using the law as a tool of liberation and equity and justice. So that is something I hope that you all might be gleaning from what we've been doing over the past year, and with respect to the seminar over the past few months. So that being said, what is like one professional skill, attribute, or value that you have come to better appreciate and that you believe will be beneficial to you in your career?
By bringing up, we kind of talked about deadlines very jokingly as being nothing like they are in law school. Deadlines are kind of a myth, whereas in law school, we have very rigid deadlines. But in all seriousness, this year, I think we learned the value of just going with the flow and being just communicative in where we are in our work. But on the flip side of that, knowing that there is a little bit more room to be gracious with one another, and to the fact that we could be a little bit more productive and come up with a better product when we are just doing our best work, and that there are only so many hours in a day that we can be working. So I'll be taking that into practice with me, that deadlines are important, but what's more important is being communicative with the people that you're working with, and just knowing that when you need extra time, it might be there. So all you have to do is ask for it.
To piggyback off that, I was going to say teamwork. Like Professor Green had hinted at earlier, like much of law school was a lot of like on your own work, but working with Kayla and Professor Green, like it's very beneficial that one, if you have a question, to ask it, but also to brainstorm and like talk to each other and try to figure out different answers to solve different problems. And where you might fall short, someone else can always pick up for you. So I think that's really important to take into the professional world.
I am an older law student, so I know that generally professionally we work together and ask for help. So I love in the real world asking for people with expertise outside of my own to like help fill in the gaps. And I feel like that the legislative practicum has been very much that way, as there's 6 of us as we work on projects for Professor Green. So if she gives us an assignment, we may all be going in our own direction, doing our research, but then to be able to reach out and say, listen, I'm not really we were looking at UK research, for example, and I was looking for case law, and the real money is in the settlements because they're less litigious as a country. And less likely to go to court. So a lot of things go to alternative dispute resolution, or go to out of court settlement. And you might find those cases, maybe if there's no NDA, in the news or in some kind of settlement disclosure document, but you're not going to find it in the case law. So while I did find what I was looking for, I didn't find like the full picture, but my classmate did, and we pieced it together, and that made for a better story, I think, of like what's really going on there in that country with their laws. So teamwork does really make the dream work, and it also makes me feel a lot better about the end work product. I like getting a grade for the work that I've done, but when I go to do legal research that is going to count for in whatever area of law that I practice, I would like it to be as, as good as it can possibly be. And I don't think that necessarily has to hinge on me alone. I kind of hope it doesn't. So, you know, also you've called in so many amazing guest speakers, and we've gotten to pick their brains. So I feel like we've talked to a lot of the best and the brightest, and just knowing that there are people that you can reach out to and lean on, and that they lean on you in that same way as an expert on Professor Green on grooming codes and many other things. So yeah.
Well, thanks. Well, one last thing, and also the value of picking up the phone, picking up the phone and calling people if you can't find it online. Not everything is online. Not everything is Googleable, right? Especially when we're dealing with the legislative process, as well as other types of things. I know all of you have had to do that, to actually call people and talk to a human being, right? About, to try to resolve an issue or to find out more information about something or get more clarity about an issue. And I have been loving seeing you all actually, I guess, utilize that old school technology. Of the telephone. It can be our friend. And doesn't only just receive text messages and memes and all these other things. It really can be actually quite helpful to us when we're trying to dig deeper into these issues. But I really appreciate you all being a part of this exchange, and as always being such great support for this work, and being deeply invested in the work. I cannot do the work without you. I hope that you all realize that Free the Hair and everything else that I am trying to do in addition to teaching would not be nearly as effective without incredible students like yourselves who are providing and providing support and helping to think through these really important issues as it relates to the trajectory of civil rights, not only in this country, but and also others.